All right, a little bit about the geography. This is an image that I promise you was randomly pulled as a common a free image off of the internet, and I actually think it's a court in Hawaii. It just has the same look to it, and it has the wood panels, but probably a court. It's a court that could be anywhere. But let's just look at the geography of the court. This is the most intimidating thing, and I wish we did this more for witnesses as well. It's like what's happening where? How's this supposed to look? And again, if you're in mock trial, you might walk into a classroom, so it looks like the same place where you're in science or something, or it could be an open area of the library, or could be something that is made to look like a courtroom just by the way they put tables together. So you got to think about the way it works in a trial in a courtroom and then apply it to this setting of wherever your mock trial is taking place. Notice that I walk in through the doors. I'm now in sort of the gallery area. I'm in the public space area. I'm where, members off the street, people off the street would walk in and sit and watch because trials are public proceedings, at least most of them. And facing me, typically near the flags, near the seal, sitting the highest, where you see indicated in the square marked A, that's where the judge would sit. That's where the presiding judge would sit. And just remember, if it's a jury trial, as most of these mock trials are meant to emulate, the judge is just making calls, just calling balls and strikes as it relates to the law or the evidence that's appropriate for the jury's ears. What can happen in this courtroom? What can be said out loud? What can be shown? The people that ultimately decide who wins or loses or what the relief is are going to be sitting over near the square marked B. That's the jury. And in a better image, in a clearer image, or a different angle of the same image, you'd actually see there's about 12 to 14 chairs over there. So it's the place that has a bunch of chairs that are isolated. They too sit a little higher. They too are in a box. You heard the expression jury box. So they are sitting. They're often on one side of the courtroom or the other. And as we look at this image, it's on the right side of the image. So you have the judge and you have B where the jury, or for mock trial, where the evaluators would sit. Um, D is, notice, a little box with one chair in between the judge and the jury. That's going to be where the witness goes, and it varies from courtroom to courtroom. It's certainly going to vary in mock trial, but just think about the witness is going to sit in a place. All mock trials have witnesses. I already talked about how witnesses are super important. So the way you need to think about it is that witness is going to sit in a place that everyone has access, everyone can see, everyone can evaluate, everyone can hear. So it's almost right in the middle of the action if you look at where the judge is and where the jury is. C, that's one of the counsel's tables, and you see it has two seats at it, could have three or more, and under the banner that says geography of trial, there's a second table that's over to the left. So just think, I told you mock trial is kind of A versus B, it's Harry versus Sally. So one of the tables is going to be for the plaintiff in a civil case, one's going to be for the defendant in a civil case, one's going to be for the plaintiff who's the government in a criminal case, and one's going to be for the defense team for the individual that's charged in the criminal case. So C is a counsel table, and that's where the lawyers would sit. If I'm a witness as part of my team, I don't sit up there. I probably sit back where we are right now in the vantage point of this photo with F, or more likely because of specific rules. In real courts, I have to sit outside, so I don't hear any of the other testimony. I'm not affected by any of the other testimony. But just know C and the table to the left, that's where the counsel tables are. And we already learned that that counsel table C that's closest to the jury, marked B, that's going to be the one for the party with the burden, or the plaintiff in this case. So if it's, if it's Harry versus Sally, that's Harry's team and Harry's team of lawyers that's sitting at that table. And Harry, of course, as the party, would sit at that table. And a witness that Harry would call, maybe witness one in his case, would make their way into the courtroom just like we are now through these kind of saloon style doors right there, go all the way up to where D sit in the chair, get sworn in, and begin the testimony. E is actually a thing I hate in this picture, but it happens in a lot of courtrooms, so I want you to know what it is. It's a lectern. It's a podium. It looks like a thing that you'd make speeches, like you see at graduation or something. A lot of judges really want you to do everything from the podium. It's mic'd up. It's got areas to present. Certainly if you're making arguments to the court, like we talked about, whether it's in a motion or an argument beforehand, you do so from a podium. But really in mock trial, one of the things you want to do is try to get away from that podium. Try to be out in the open. Try to be in the best place that we'll talk about to ask your questions or to make your jury address, and not be hidden behind or covered by the podium. It's a different talk for a different day, but I want you to know that that's a podium, and some judges are going to make you adhere to it, and you try your best to listen to what the judge is saying. All right, rules and customs. Talk about something, a topic that could be its own video. So I'm going to go simply like this. The rules, there are procedural rules about, like we talked about, who goes first, who sits where, um, the order of trial, the fact that there's a jury address, and then there's a defense opening statement, and then there's witness one and witness two. Those are all procedures. And the most important rules that happen, and it happens in mock trial as well, all the way down to high school mock trial, are the rules of evidence. Federal court, we have the federal rules of evidence. In every state court, they have that state court's rule of evidence. I practiced in the military for a little while. We have the military rules of evidence. So there are always rules of evidence. And when I say evidence, and when I say the rules of evidence, what I mean is there's a system of rules that are governing what can happen at trial, what a proponent of evidence, what the person presenting evidence can actually do, what questions can they ask, um, what evidence can they put in, what arguments can they make. And just like any rules, most of them are thou shalt not, or you cannot do something. And in the American justice system, we actually put it on the opponent. So if I'm the plaintiff in a civil case and I'm presenting evidence through my witness one who saw the car accident, I might be asking questions on direct. If I've done something wrong, if I've violated these rules, if I've asked a question about something I'm not supposed to put out there in a courtroom for the jury to hear, we put it on the other side. We put it on the opponent of that evidence. So I'm the plaintiff, I'm the one presenting the evidence, my opponent is the defense. If I've done something wrong, they're the ones that have to do something about it. And we all know, because we watch TV and the movies, they have to object. They stand up, they clearly say objection, and then they offer a basis. Objection, this is irrelevant. Objection, unfairly prejudicial. Objection, this is hearsay. So they use the rules of evidence and the articles of these rules of evidence to say the person presenting, the person doing what they're doing, is about to misstep, is about to do something that they shouldn't do. So there are rules and there's guidance, but we put it on the other side. So I think a lot of people, if you quiz them and if you ask them, they think, and some of this is distorted by TV and the movies, they think the judge is responsible for enforcing the rules. The judge is responsible for ruling on objections when raised. But frankly, if someone's asleep at the wheel as opposing counsel and a bunch of inappropriate stuff is happening in the court, a lot of times that falls to why lawyers matter and why you shouldn't hire an attorney who's asleep. The judge can do things on their own, but it's not the way you should rely on it, and certainly not the way you should do it for mock trial. So the rules, procedural rules, and rules of evidence. Customs, again, could be its own video, could be its own highlight. But what I want you to think about, we're going to cover it during parts of this course. I mentioned one already. Where people sit, that's a custom. Where people wear, what people wear, you're going to wear your best. It's a suit and tie for men. It's a business formal for women when you're in court. That's a custom. When you're addressing the court, you stand up, at least in most courts in the United States. Certainly in mock trial, you stand up. So even if you say, hey, do you have any problem with that evidence, lawyers for the plaintiff? Nah, you just violated a custom. You have any problem with that evidence, lawyers for the plaintiff? I stand up because words out of my face are going to go to the court, and I say, no, Your Honor, and I sit back down. So I punctuate things with Your Honor, and I talk very formally with no and yes. And in real court, you'd have a court reporter, you'd have a transcript, and you want it to reflect some of those customs. So standing up, where you sit, what you wear, how you deal with things. I'll tell you another one. We'll talk about it in sort of how I favor, how I evaluate who's going to be more successful, how do I succeed in mock trial, those videos that are to come. But something as simple as we all lose our space at times, or we just need a conference with co-counsel and go back to the table. Maybe we got flustered because we got objected to a few times, or maybe we're just not sure what our next question is. If you're inexperienced, you say, Your Honor, I need to go meet with my co-counsel. That kind of sounds like someone in a high school class that needs to go talk to their friend. In a custom of trial is you're asking a question, you need that type of break. Your Honor, may I have a moment to confer with co-counsel? You may. Go over, have your conference very formally. Your Honor, may I resume with my examination? You may. So it's overly polite. It might even sound a little too much, but it projects professionalism. You reflect as a professional, and actually more like the way a lawyer talks. So punctuate. Yes, Your Honor. May I resume? Your Honor, may I have a moment? Your Honor, at this time, may I approach? Uh, may I display on the overhead projector exhibit number 4 already in evidence? So a lot of formal language is part of the customs. There's many, many more, and I hope to hear about them in the comments and by email. I want to end with the limits and goals of trial. Some of this is a mindset. Some of this is the way you need to think heading into trial. I think some mock trialers, some new advocates, frankly, some new attorneys don't recognize that trial is a disjointed process. It's an order and a batting order and a way of conveying information that is necessarily one side goes, then the other side goes, and the one side objects and they respond, and then they put on more evidence. It's disjointed. It's not like giving a speech. It's not like making an argument to an appellate court. It's kind of all over the place. The idea that you can't just explain it to people, but that you have to call witnesses, characters from the place that aren't lawyers, that sometimes aren't sophisticated, that sometimes aren't articulate, to try to get bits of information to the jury. So one of the limits of trial is understanding you can only control what you can control. It's a great life lesson too, but you can prepare a witness, you can call a witness, you can ask questions of a witness, and you can talk to them about, given their prior testimony or given what they saw, what's an appropriate answer and what's the best answer to convey what they mean. But there's limitations to it. You can't control what the other side asks. You can't control what some of those answers are going to be from your witness during cross-examination. You can't control objections that are going to come or how the judge is going to react to them. So the idea of understanding, and I see people get jammed up with this sometimes, especially folks new to the process and mock trialers that are new to the process. It's not just your voice. It's not just your theory. It's not just your theme. It's not your way of looking at the case. There's more voices in the room. There's more going on. So what I would caution you to say, there are limitations. There are limits to trial. And the limit is you can only control what you're going to control. Now, the flip side of that is you will have goals. And your goal is that what you plan to get out. If I have a witness on direct examination, I'm presenting, I'm the proponent, I call a witness in my case, I'm the plaintiff, I call W1. I have a plan for that witness. I have questions, I have topics, and I have information and exhibits that I want to get in. My goal for trial, my goal for that examination within that trial is I want to get that information as close to what I need in the end of the day. And oftentimes we teach trial advocacy and how to look at the arc of a trial backwards. What do I want to say in closing argument? What do I want to be able to stand up and explain to people in the jury at the end dictates what I do during trial. If I want to talk about a certain witness in a way and talk about their testimony in a way, well, I better get that information when they're on the stand and when I have them on direct examination. If I want to talk about the other side's witness and why they shouldn't be believed or why their credibility may be impaired, well, I better ask the right questions and I better do something at trial during my cross-examination to be able to make that argument credibly to the jury. So one of the things I would think about is my goal is, what do I want to say in closing? My goal is to do everything during trial to be able to have those arguments available to me. I want to get my plan for trial, my analysis for trial, the why I think I'd win, my theory of trial. I want to get it as close as possible when we come off of the right way. You're going to hear a famous expression if you read some trial advocacy books. There's the trial I planned for, the trial I have, and then the trial I wish I had. For those of you in school, it's not unlike taking an exam. You're looking forward to the exam, you're thinking about what there's going to ask. Then there's the exam you take, and then for the night after, while you're trying to sleep, in the days after, you're thinking, what was that exam? What did I really answer? You're always kind of looking forward to it, you're in it, and then you're looking back upon it. You want to try to get those aligned as best as possible. What am I planning for? What actually goes down at trial, and how close is that when I'm thinking back on it as that was the trial I hoped to put on? Kind of results be damned, results aside, especially mock trial results with who wins and who loses. Do what you can control, do what you plan. Those are some of the limits and goals of trial. Again, special credits. Look out for the future videos. Homework coming away from this one. I want you to think about some of these things, the roles, the players, the batting order, and all those things, and watch some good legal movies. My Cousin Vinny, A Few Good Men, Philadelphia with Denzel Washington. Great movies. If you watch them and you email me or you fill out um, something in the captions or the comments to these videos, who's the proponent? Who's the plaintiff? What type of case is it? Is it a civil case or is it a criminal case? Are people standing in the right place? I can tell you that these movies have some critical errors in the way that it's supposed to work. So look at them and try to point out some errors about geography, about roles, about different things that go on at trial, even as it relates to these basics. So as I started out, um, this was my attempt to try to get you off the ground, try to get us. I expect that most people were familiar with most of the things I said, and hopefully you picked up a few things. What'd you pick up? Let me know by email. Let me know in the comments. What am I missing as it relates to basics? We're going to cover a bunch of things going forward in these 10 videos coming up. But as it relates to basics, what are we missing? What do you need to know? I hope that you share some thoughts with me, and then we'll get some things up on video. Aloha.